If you have suffered discrimination in the workplace, there's a couple of things you need to understand about making a claim for discrimination. Firstly, if you've been treated badly, but it's due to the poor management or unprofessional approach of a manager or a supervisor or colleague, that doesn't necessarily mean that it's a discriminatory situation and will give rise to a discriminatory claim. You must be able to put your claim into one of 9 categories of discrimination. So in the Employment Equality Act of 1988 and after, there are 9 grounds of discrimination. They will include race, religion, family status, membership of the travelling community, ethnic origin, and so forth, disability. These are all grounds of discrimination. So the first thing you need to understand is if you're going to bring a claim for discrimination arising from the employment situation, you must be able to put the behaviour about which you claim into a discriminatory category. It's not just enough that it's rough treatment or unprofessional approach by the manager. Let me give you an example. Say you're from Slovakia or say you're from Poland and you claim that a particular manager has treated you badly for a period of time and you claim it's a discriminatory situation. If, however, that manager also treats an Irish person in the same way, then obviously you can't bring a claim for discrimination on the grounds of race or nationality, because clearly the treatment that you're receiving isn't because of your origin or your country of birth. It may be just because of very, very poor management. On the other hand, it may be because you are, for example, a woman or a member of a particular region. If that's the case, then that will be your discriminatory ground, but you do need to get your claim into a discriminatory ground in order to ground a claim, a successful claim for discrimination. That's the first thing. So bad management, rough management, an unprofessional approach by a colleague or a supervisor or a manager doesn't necessarily mean it's discriminatory just because you are not from Ireland or because you're a man or because you're a woman or because of your religion. That leads on then to the next question. And the next question is the burden of proof. The Employment Equality Act of 1988 puts the burden of proof in the first instance on the complainant, that is you as an employee. So if you claim you're being discriminated against, then you must prove your claim. But quite frankly, the burden of proof on you isn't very high and it's not that onerous. What you need to do, and it's set out in the legislation, is you need to establish facts from which a reasonable inference can be drawn that you've been discriminated against. If that's the case, then the burden of proof shifts from you to the employer or to the person who you claim has discriminated against you. That's a very, very important distinction, because it's not like a criminal prosecution or criminal burden of proof where you must prove beyond a reasonable doubt that you have been discriminated against. You don't actually need to do that. What you need to do is establish facts from which a reasonable inference can be drawn that you were discriminated against. Once you've done that, once you've got over that hurdle, once you have established that prima facie case, then the burden shifts to your employer and he must prove, or she must prove, that you were not discriminated against. This is very, very significant. Third point I'd make to you is that a harassment or a sexual harassment claim is essentially a discrimination claim. And again, the same burden of proof arises. In other words, if you can establish that you have been reasonable facts, or facts from which a reasonable inference can be drawn that you have been discriminated against or harassed, or sexually harassed, then the burden of proof shifts to the employer. However, in the legislation, in the Employment Equality Act of 1988, there is a defence for the employer. And there's 2 parts or 2 prongs to this defence. One is that the employer has procedures and policies in place in the workplace to prevent discrimination and to prevent harassment and to prevent sexual harassment. So that's the first burden or first aspect of the statutory defence for employers. The second aspect is that once harassment or sexual harassment has occurred, that the employer has taken reasonable steps to redress the balance or redress the damage or make up to you having suffered sexual harassment or harassment in the workplace. So there's two aspects, as I say, to the employer's defence. In a sexual harassment case, in a harassment case, it's set out in the Employment Equality Act, and it is A, that there is procedures and policies in place in the workplace, and B, that the employer has taken steps to remedy the damage that you've suffered. That may be a satisfactory defence for the employer. However, if the employer doesn't have the policies or procedures, or does have policies and procedures and doesn't implement them fairly and consistently, or if the employer has received a credible complaint of discrimination or harassment and hasn't done anything about it, or hasn't taken reasonable steps to redress the damage, then the employer's defence may be out the window. And finally, one other point that I'll make just in relation to discrimination-based claims and harassment-based claims is that in an unfair dismissal or constructive dismissal situation where you leave the work, you may be obliged to leave the work because of the experience you've had in the way of sexual harassment. Then if you bring a claim for constructive dismissal, you must prove that you've tried to get alternative work after leaving the job. Whereas in a discrimination-based dismissal case, you don't actually have to prove that you try to mitigate your loss. What you need to prove is that you've suffered the sexual harassment or the discrimination. That is a subtle difference, because ultimately if you do leave your job and bring a claim for constructive dismissal and or discrimination, you will be obliged to choose between one or the other. And obviously it'll depend on the facts, depend on the circumstances of the particular case. But the discrimination-based claim, if you go with that, you don't actually have to prove that you've tried to mitigate your loss or get new work, and you're not tied to just financial loss, because in a constructive dismissal or unfair dismissal claim, you're tied to your remedy, your damages, your recompense, compensation, call it what you like, is going to be financial loss. That is, your out-of-pocket wages for the period of time. Whereas in a discrimination-based claim, that is not the case. An award of up to 2 years' salary can be made in a discrimination-based claim. So that's an important distinction, and one that you may have to choose between if you leave your job as a result of discrimination or harassment. You can find out a lot more about discrimination and equality at work and sexual harassment and discrimination and the 9 grounds on my website, employmentrightsireland.com. There's a lot of free information on the site. Feel free to go ahead, search through it, go over to the right hand side of the website. There's a search box there, put in discrimination or sexual harassment, whatever, and you'll get a lot of articles, useful articles I believe, on this whole area. If you find this video useful, you might give it a thumbs up down below, and you may also be interested in subscribing to my YouTube channel. If you are, just hit the subscribe button down below, and thanks for watching.